I want to go back to the publication by Professor Andy Gruwell of the University of Iowa School of Law and the blog post, and I'd like to ask that we would unanimous consent to submit this for the record.
Without objection.
And it's already been said, the post details those final regulations from the IRS on the eligibility for premium tax credits. We see the regulations give credits to taxpayers who are automatically enrolled in the employer-sponsored minimum essential coverage, even though the IRS has acknowledged that the individual is not eligible for the tax credits. Unbelievable to me that that could be taking place. Congress has explicitly denied these premium tax credits to individuals who are receiving health benefits from their employers. I'm extremely concerned that this policy will lead to employer penalties. I've actually had employers call me and tell me they are concerned about this personally, about what this is going to mean to them. They are trying to abide by the law. They're trying to meet all the regulations. Obviously, the regulations were late coming out. They were supposed to start with reporting mechanisms in January. They didn't get the final regulations until February. It's costly to them and so on. Can any of you address the impact that you believe this will directly have on employers? Ms. Turner, why don't I start with you?
Employers have just, as we mentioned before, has just been run through the ringer in trying to comply with this law. And this is a relatively obscure provision that Professor Gruwell has found among several others when he has looked at the statutory language and the significant conflict. But employers are doing the right thing here and trying to provide coverage to their employees. They're following the law often with automatic enrollment. And if that happens, then this person still goes to the exchange for coverage. And if it is allowed because of this breach of the federal rules, it puts the employer in an impossible position. Even doing their best to comply with the law is not possible because the law is in conflict with itself, and really shows the extraordinary difficulty of changing a law as you go along and the repercussions and the chain effect that requires.
It is a huge concern, and it's apparent that this administration does not have the capability of accurately verifying eligibility for these subsidies, and they've had repeated illegal workarounds on the law that have exacerbated this situation. For instance, in 2015 plan, the CMS implemented a policy that I believe is outside of the bounds of the law once again, where they automatically re-enrolled individuals into the exchange coverage, even if they did not proactively select a new plan. And in that, they based their subsidies on income information that was out of date. They knew it was out of date. It was based on 2014 enrollment applications. And according to their own Office of Assistant Secretary for Planning and Analysis, nearly 2 million people were enrolled in coverage via this method that is going to potentially set up for not only a waste in taxpayer dollars, but also the issue of the what it will do for the employers. And Ms. Papez, would you please address what you would say is the legality of what is happening with this automatic enrollment using numbers that are not verified? Is it legal? Do you believe that this is something that would, if it were in a court of law, be seen as illegal?
I think that the question goes to a point you raised, which is you'd start with, does the statute speak to this issue? And to your point, if a statute speaks clearly to an issue, there is very little administrative discretion to depart from that. So I think that's the first point. I think the second point is one we've discussed a little bit, which is to the extent that the agency has discretion on implementation, there has to be, and there are other statutes like the Administrative Procedures Act that speak to us, there has to be a rigorous process for documenting, announcing, and justifying the manner in which particular programs are implemented, the way particular decisions are made. And there are a number of APA cases, for example, in the federal courts in DC here that take the position that if an agency action that affects real rights and real issues is based upon numbers or statistics or findings that are not actually verified and do not have an appropriate factual basis in the administrative record, then they are void as a matter of law, and the agency has to go back to the drawing board.
Thank you. And Mr. Chairman, I want to thank you for having this hearing today, because it is our responsibility to oversee the administrative policies and the lack of following the law, and I applaud you for allowing us to bring this forward.
Thank you.